This is Banwo and Ighodalo's special legal podcast, with focus on thorny matters and novel issues in the legal and regulatory environment impacting transactions in this jurisdiction. On this podcast, you will listen to Banwo and Ighodalo's legal experts bring to the market on a weekly basis fundamental developments and emerging issues in legislation, regulations, judicial decisions, and arbitral proceedings considered to be of interest to the legal market and to domestic and international investors across sectors of the economy.
Welcome to another episode of Banwo and Ighodalo's podcast. This podcast will focus on the emerging jurisprudence of the National Industrial Court regarding termination of private contractual employment. We will also be focusing on the implications of that emerging jurisprudence for employers. I'm here in the studio with Chinedum Umeche, who is a partner in the Litigation, Arbitration and Alternative Dispute Resolution Practice Group at Banwo and Ighodalo. Chinedum is a seasoned dispute resolution expert with years of expertise handling commercial litigation for a wide range of clients. He has advised in his course of working experience several industries including energy, financial services, FMCG and telecommunications. Chinedum, you're welcome.
Thank you, Mayokun.
I'm also here with Adeola Agunbiade, who is a seasoned litigator and has advised on several issues ranging from contractual breaches arising from complex commercial transactions, enforcement of contractual rights, construction disputes, and expropriation of economic rights and employment disputes. She's been involved in several multi-jurisdictional litigation disputes and has also advised a range of clients in several industries. Adeola, you're welcome.
Thank you, Mayokun. It's my pleasure.
As I mentioned earlier, today we'll be focusing on the emerging jurisprudence of the National Industrial Court in relation to termination of private contractual employments and its implications for employers. So let's get right to it. As I mentioned, there's an emerging jurisprudence by the National Industrial Court regarding private contractual employment and the requirement that such employments can only be terminated by employers after giving valid reasons. Adeola, could you please help us with a background to this jurisprudence?
Thank you, Mayokun. Indeed, the National Industrial Court of Nigeria, which is the court that has exclusive jurisdiction over labor and employment matters in Nigeria by virtue of Section 254C of the Constitution, the 1999 Constitution as amended, has in recent years turned away from the erstwhile principle that an employer is entitled to terminate the employment of an employee for good or bad reason or for no reason at all. Before then, the law, as we all knew it, is that in contractual private employment relationships, an employer can hire and fire at will and for no reason at all, provided the contractual requirements are complied with. I mean, this is a position that the Supreme Court has had on dear over the years and had affirmed, as recent as 4 years, 3 years ago. In fact, even the National Industrial Court itself had affirmed the same position in some of its decisions, the position that an employer needs not provide reason. And in doing that, what they basically did was to just affirm the Supreme Court's jurisprudence on the matter. But what we've seen, especially from 2011, is that there's been a subtle agitation by the National Industrial Court to fashion out a new jurisprudence. And the new jurisprudence, according to them, is that going forward, a valid reason must be provided by the employer before termination of an employment contract. We saw that even in another decision in 2008 by the National Industrial Court, that's the Pengasin and the Schlumberger's decision. In that case, Schlumberger's counsel had, in one of his submissions to the court, said to the court that, Schlumberger need not provide any reason before terminating the employment of its employees. And the court had just, in passing, in responding to that argument, simply said, while we don't have a problem with that, the point must be made that globally it's no longer fashionable in industrial relations to terminate an employment without providing reasons. But it was as if the court wasn't sure of that position, because the court had even prefaced by saying, well, why we don't have any problem with that, just know that it's no longer fashionable. But what we have now seen since 2015 is that the court has been very bold in taking this approach, because in 2015, in the popular Halocious and Diamond Banks case, the court went fully on and said it's now contrary to international labor standards and international best practice, and therefore unfair for an employer to terminate without providing a reason that is either connected with the performance of the employee's work or a reason connected with the employee's conduct, and thirdly, a reason connected with the operational requirements of the undertaking. We've seen since, subsequent decisions of the National Industrial Courts follow this pathway.
Thank you very much, Adeola. That was very expansive. What I hear you say is that the National Industrial Court has now departed from the jurisprudence that the Supreme Court has harped on over the years, and that now there's a departure. Chinedum, could you help us expatiate on why this departure exists and if it's justified?
Yeah, thank you very much, Mayokun. You're right about the use of the word departure, because Nigeria operates a system of, or applies a system of judicial precedence where lower courts should follow the decisions of higher courts. But what we have seen here is a slight tension, so to speak, between principles of common law as we know it and the emerging jurisprudence of the National Industrial Court pursuant to Section 254C of the Constitution. Now, under the common law, it used to be that an employer could terminate the employment of its employee for any reason or for no reason at all, provided the requisite notice has been given or salary in lieu of notice has been paid. But what we are seeing with the emerging jurisprudence in the National Industrial Court is that such principles no longer hold sway. Now, all of the Supreme Court decisions, which Adeola referenced earlier, have been cases that got to the Supreme Court before the enactment of the new provision in the Constitution. And so we are yet to see a decision of the Supreme Court on the new provision. And we may never see it because under the new jurisprudence, under the new legal framework, the Court of Appeal is the final court for employment matters. But yes, the National Industrial Court has justified its decision to interrogate termination of employment on certain provisions in the Constitution, for example, Section 254C, 1, F and H, which, when read together, empowers the National Industrial Court to consider civil causes and matters related to or connected with unfair labor practices, international best practices in labor, employment and industrial relation matters, and to apply international labor standards. Now, pursuant to all of these provisions, the NICN has justified its decision to insist that employment relationships can no longer be terminated unless a valid reason has been provided. There's also the provisions of the National Industrial Court Act, I think that's Section 7, Sub 6, where the National Industrial Court is permitted to have due regard to good or international best practice in labor or industrial relations. So all of this, when taken together, is what the National Industrial Court has justified in insisting that termination of employment must now be done by providing a valid reason. Thank you.
Well, thank you very much for that, Chinedum. And just to be clear, what we're saying is that the National Industrial Court has now placed a requirement on employers based on an international best practice. Am I right?
Yeah, absolutely. I mean, that's the growing jurisprudence. And, well, we have seen, like Adeola said before now, we have seen varying decisions. It doesn't seem that they are quite certain as to what the position is. But what is clear is that it's no longer fashionable, or the common law principles as we know it is no longer applicable. And so the emerging jurisprudence is that termination must be done in accordance with international best practices, which essentially means that you have to provide a reason for such termination.
Thank you very much. And over the course of my personal reading, I've found that the international best practice that the National Industrial Court harps on appears to be contained in a convention by the International Labour Organization, specifically the Termination of Employment Convention of 1982. Adeola, could you help us understand this? Because I hear also that there are arguments relating to whether the National Industrial Court can validly apply principles in that convention. There's also the interplay between sections of the Constitution. Can you break this down for us, Adeola?
Indeed, Mayokun. Of course, there are two arguments on this question that you've raised. So some people would say that to the extent that you have, in section 254C2, which says the NIC has jurisdiction to apply international convention or protocol relating to employment or labor matters that have been ratified. If the National Industrial Court is going to be relying on the ILO Convention on Termination of Employment, then it can only do that if that convention in question has been ratified. And as we may know, the convention as at date hasn't been ratified by Nigeria. So there is an argument on one hand that, looking at section 254C2, the National Industrial Court should only apply conventions that have been ratified. But again, that's not all there is to that argument. Some other people would argue or say that to the extent that you also have different provisions, or to the extent that you have section 254C1F and H, which is kind of generic, and says the NICN should have jurisdiction in civil causes and matter which relates, to unfair labor practice or international best practices in labor, or, should be able to apply international labor standards generally, that the National Industrial Court can very well come under the general provisions of section 254C1F and H. So I guess in summary, you have those who would say, strictly looking at section 254C2, the National Industrial Court should only apply conventions that are ratified. And then you have people who would say, looking at section 254C1F and H, the National Industrial Court, should have, or indeed has generic powers to look at international best practices.
Thank you very much, Adeola. I've read the Constitution, and I don't see anywhere that it defines what international best practices is. And this leads me to my next question. Chinedum, you'll be kind enough to help us here. What is international best practice, and why is there so much pronouncement on what the ILO says, ILO, International Labour Organization? Could you help us wrap our heads around what international best practice is?
Well, Mayokun, that's an interesting question. International best practice, could be defined as what obtains internationally, or what is accepted internationally as to practice in any given situation. And you're absolutely right. The Constitution does not define what constitutes international best practices, and therefore the National Industrial Court has had to look to, for example, provisions of the international conventions issued or prepared by the International Labour Organization and ratified by member nations. As you know, the ILO, that's the International Labour Organization, it's a United Nations agency that is concerned primarily with labor matters, and it is accepted worldwide as the organization that sets minimum standards for labor-related matters. And therefore, we can argue that the ILO Convention on Termination of Employment, at the very least, contains baseline provisions that can arguably constitute international best practices. But if we interrogate further, you will see that the ILO Convention on Termination of Employment has only been ratified by, I think, just 33 countries out of 150 countries, member nation of the United Nations. And so the question will be, how does that sit in terms of majority, if 33 out of 150 countries? But I think we can ignore that argument for a second and consider that the ILO Convention is the benchmark, and that countries can then either improve on it, but at the very least, they shouldn't go below its provisions. There's also the argument that countries should understand their local nuances in terms of applying these provisions. And so there's always that constant tension between courts of various countries, especially in the situations where the ILO conventions have not been ratified or domesticated, as it were, in those countries. I don't know if it answered your question, but I think that's the position.
You have, and I think that our listeners are also very much enlightened by your response. Thank you very much for that. By way of summary, we have established that the National Industrial Court has now moved away from the position of the Supreme Court and have now enshrined in our law that employers need to give valid reasons before terminating their employees. We have also learned that the National Industrial Court is increasingly looking towards the International Labour Organization in respect of this issue, particularly the Termination of Employment Convention of 1982. But let's be practical now. What are the things that employers should do going forward? Adeola, any thoughts?
Well, I think from a practical point of view, until the Court of Appeal has an opportunity to pronounce on this new jurisprudence, one of the practical things that employers can do going forward is make sure that as much as possible, it could increase the administrative requirements of employers, but it's just what it is, to make sure that going forward as much as possible there is proper record keeping, especially because now the National Industrial Court has said if you're terminating, it has to be related to the performance or conduct, to have proper record keeping, performance reviews, so that if an employer is going to rely on that going forward, at least there's some sort of documentation to back up whether an employee has performed well or performed below par, and in relation to conduct as well, make sure that there's also proper recording of disciplinary measures, of any infraction, no matter how little. So you can't have too many papers going forward.
Thank you very much, Adeola. Chinedum, any thoughts?
Well, I find in my practice or in my experience that there's often a misalignment between HR functionaries and those in the legal departments. And so we have HR functionaries who may not be well aware of the emerging jurisprudence, and then they can potentially put their companies in a litigation battle, which can be avoided. So I think that organizations should ensure that the HR functionaries are abreast or understand fully what the emerging jurisprudence is and the requirements for compliance, obviously in a bid to mitigate needless litigation. There's also the need for the National Industrial Court to, or I should say the Court of Appeal, to take a definitive position so that there's some kind of clarity on the point. It's helpful, especially for those of us who routinely advise organizations, to understand what the law is once and for all, and so that there's no confusion at all as to whether the common law provision still applies or whether the new normal will be to stick to the growing jurisprudence that has been developed and seem to be taking hold across the country.
Well, thank you very much for the illuminating session. We're grateful for your time, and I'm sure that our listeners are also much improved to this session. Thank you very much, dear listener, for joining us today and enriching yourself with our podcast. We do hope that you come to Banwan Ugodalu for any questions that you may have regarding your employment-related issues. Thank you very much.
Thank you for listening to this episode of Banwo Anigudalu's Legal Podcast. For more insights, hit us up across any of our socials, that is on Instagram or Twitter, at Banwo Anigudalu or at Africa Business Radio.